It is generally recommended to pre-lien all of the owners and the tenants in common building before starting substantial work. A reference for this can be found in California's Civil Code Section 3111, which pertains to mechanics lien law. The reasons for pre-liening include protecting your rights, preventing conflict, and avoiding lien lapse. Filing a pre-lien secures your right to payment for the work you perform. By pre-liening all owners, you avoid potential disputes about who is responsible for payment if the primary owner defaults. Pre-liening ensures that your lien remains valid for 90 days from the date of the first work performed, even if the work is not completed within that time frame. The process of how to pre-lien involves firstly, drafting a preliminary notice of lien to each owner, secondly, serving the preliminary notice of lien on each owner in person, by mail, or by posting it on the property, and thirdly, filing the preliminary notice of lien with the county recorder's office. It is important to note that the pre-lien does not create an actual lien on the property. It is merely a notice of intent to file a lien if payment is not received. If you do not receive payment within 30 days of completing the work, you can file a mechanics lien to secure your payment rights. It is always advisable to consult with an attorney specializing in construction law for specific guidance on pre-liening and other legal matters related to your project. Mechanics liens are legal claims against a property to ensure payment for labor, services, or materials used for improvements. Understanding the nuances of mechanics liens, particularly in the context of tenants in common TIC arrangements, is crucial for contractors and subcontractors. Firstly, the nature of tenants in common needs to be understood. In a TIC arrangement, multiple individuals own undivided interests in a property. This means that each owner has a right to possess and use the entire property, even though their ownership share may be different. When improvements are made to a TIC property, it can be challenging to determine which owner or owners are responsible for payment. Pre-lien notices, also known as preliminary notices, are essential for protecting a contractor's or subcontractor's lien rights. These notices inform the property owners that the contractor or subcontractor is providing labor, services, or materials to the property and that they may have the right to file a mechanics lien if they are not paid. In the context of TIC properties, it is generally recommended to serve a pre-lien notice on all of the owners, even if only one owner has directly contracted for the work. This ensures that all owners are aware of the potential lien claim and avoids disputes later on. California's Civil Code Section 3111 provides specific guidance on mechanics liens in California. This section outlines the requirements for filing a mechanics lien, including the timeframes, notice requirements, and enforcement procedures. Contractors and subcontractors working on TIC properties in California should carefully review Section 3111 to ensure that they comply with all applicable requirements. Several reasons exist for pre-liening all owners in a TIC building. 1. It protects your rights. Filing a pre-lien notice secures your right to payment for the work you perform. Without a pre-lien notice, it may be difficult to enforce a mechanics lien if the owner who contracted for the work fails to pay. 2. It prevents conflict. By pre-liening all owners, you avoid potential disputes about who is responsible for payment if the primary owner defaults. This can help to streamline the payment process and minimize the risk of litigation. 3. It avoids lien lapse. Pre-liening ensures that your lien remains valid for 90 days from the date of the first work performed, even if the work is not completed within that time frame. This can be important if there are delays in the project or if the owner is slow to make payments. The process for pre-liening typically involves these steps. Firstly, draft a preliminary notice of lien to each owner. The notice should include the name and address of the contractor or subcontractor, the name and address of the property owner, a description of the work performed or materials provided, and the estimated value of the work or materials. Secondly, serve the preliminary notice of lien on each owner in person, by mail, or by posting it on the property. The notice must be served within 20 days of the date that the contractor or subcontractor first provided labor, services, or materials to the property. Thirdly, file the preliminary notice of lien with the county recorder's office. This provides public notice of the potential lien claim and helps to protect the contractor's or subcontractor's rights. It is important to understand that a pre-lien notice does not create an actual lien on the property. It is merely a notice of intent to file a lien if payment is not received. If you do not receive payment within 30 days of completing the work, you can file a mechanic's lien to secure your payment rights. A mechanic's lien is a legal claim against the property that allows the contractor or subcontractor to foreclose on the property if they are not paid. Consulting with an attorney specializing in construction law is always advisable for specific guidance on pre-liening and other legal matters related to your project. Construction law can be complex, and an attorney can help you navigate the legal requirements and protect your rights. Furthermore, there are some additional considerations for pre-liening TIC properties. Firstly, it is important to identify all of the owners of the property. This can be done by searching the county recorder's office records or by contacting a title company. Secondly, it is important to ensure that the pre-lien notice is properly served on all of the owners. This may require hiring a process server or sending the notice by certified mail with return receipt requested. Thirdly, it is important to keep accurate records of all work performed, materials provided, and payments received. This will be essential if you need to file a mechanic's lien. Pre-liening all owners in a TIC building is a best practice for protecting your payment rights. By following the steps outlined above and consulting with an attorney, you can minimize the risk of disputes and ensure that you are paid for your work. The preliminary notice, also known as a pre-lien, is a critical document in the construction industry, especially in states like California, where it's governed by specific statutes. It serves as a notification to the property owner, general contractor, and lender if any that a subcontractor, supplier, or other party has furnished labor, services, equipment, or materials to a construction project. It doesn't create an immediate lien on the property, but is a prerequisite for filing a mechanic's lien later if payment issues arise. Firstly, let's delve into the purpose of the preliminary notice. The primary reason for sending this notice is to protect the payment rights of those who contribute to a construction project but don't have a direct contract with the property owner. It establishes transparency and ensures that all parties involved are aware of who is working on the project and their potential claim against the property if they are not paid. Secondly, the timing of sending the preliminary notice is crucial. In California, for instance, it must be served within 20 days of the date the claimant first furnishes labor, services, equipment, or materials to the project. Failing to meet this deadline can significantly impair the claimant's ability to file a mechanic's lien later. Thirdly, the content of the preliminary notice must adhere to specific legal requirements. It typically includes the name and address of the claimant, the name and address of the property owner, a description of the work performed or materials provided, the estimated value of the work, and a statement that the claimant may have a right to file a mechanic's lien if they are not paid. Fourthly, serving the preliminary notice correctly is essential. It can be served personally, by registered or certified mail, or by leaving it at the recipient's residence or place of business with a person in charge. Proof of service, such as a return receipt or affidavit, is vital for demonstrating compliance with the law. Fifthly, the preliminary notice benefits all parties involved. It gives the property owner an opportunity to ensure that all subcontractors and suppliers are paid, preventing potential liens on their property. It also allows the general contractor to track who is working on a project and manage payments accordingly. Sixthly, there are exceptions and special cases to consider. For example, a direct contractor, one who contracts directly with the property owner, typically doesn't need to serve a preliminary notice. However, it's always advisable to consult with a construction law attorney to determine the specific requirements for your situation. Seventhly, the preliminary notice is not a substitute for a mechanic's lien. It's simply a preliminary step that preserves the claimant's right to file a lien later if necessary. If payment issues persist, the claimant must still file a mechanic's lien within the statutory time frame. Eighthly, the cost of serving a preliminary notice is relatively minimal compared to the potential cost of losing lien rights. It's a small investment that can provide significant protection in the event of a payment dispute. Ninthly, keeping accurate records of all preliminary notices served is crucial. This includes copies of the notices, proof of service, and any related correspondence. These records can be invaluable if a lien claim becomes necessary. Tenthly, the laws governing preliminary notices can vary from state to state. It's essential to understand the specific requirements in the jurisdiction where the construction project is located. In summary, the preliminary notice is a vital tool for protecting the payment rights of subcontractors, suppliers, and other parties in the construction industry. By understanding its purpose, timing, content, and service requirements, you can ensure that your lien rights are preserved and that you are paid for your work. Always consult with a construction law attorney for specific guidance on your situation. Let's discuss the implications of not pre-liening in a tenant-in-common arrangement. Firstly, without a preliminary notice, your ability to file a mechanic's lien can be severely compromised or even eliminated. The preliminary notice serves as a formal notification to the property owners that you are providing labor or materials to their property, thus establishing a clear record of your involvement and intent to seek payment. Secondly, you risk facing significant delays in payment. Property owners may be unaware of your contribution to the project, and without the formal notice, they may not prioritize your payment. This can lead to cash flow problems and hinder your ability to complete the project or take on new work. Thirdly, you may encounter disputes over the scope of work or the quality of materials provided. Without a preliminary notice, it can be difficult to prove that you were authorized to perform certain tasks or supply specific materials. This can lead to disagreements with the property owners and potentially result in legal action. Fourthly, you may have difficulty enforcing your payment rights in court. Without a preliminary notice, it can be challenging to establish a valid claim for payment. The court may rule against you if you cannot provide sufficient evidence that the property owners were aware of your involvement and agreed to pay for your services or materials. Fifthly, you may damage your reputation in the construction industry. Failing to protect your payment rights can be seen as a sign of unprofessionalism or financial instability. This can make it difficult to secure future contracts or maintain good relationships with other industry professionals. Sixthly, you may lose the opportunity to negotiate a favorable payment arrangement. When property owners are aware of your potential lien rights, they may be more willing to work with you to resolve payment issues. However, without a preliminary notice, you may have less leverage to negotiate a fair payment arrangement. Seventhly, you may be forced to accept a lower payment than you are owed. If you are unable to file a mechanic's lien, you may have no choice but to accept a reduced payment or write off the debt entirely. This can significantly impact your profitability and financial stability. Eighthly, you may incur additional legal fees and expenses. If you have to pursue legal action to recover payment, you will likely incur significant legal fees and expenses. These costs can quickly add up and further erode your profits. Ninthly, you may experience increased stress and anxiety. Dealing with payment disputes can be stressful and time-consuming. Without the protection of a preliminary notice, you may feel overwhelmed and anxious about your financial situation. Tenthly, you may miss out on other opportunities to protect your payment rights. A preliminary notice is just one tool that you can use to protect your payment rights. There may be other legal remedies available to you, such as filing a stop notice or pursuing a breach of contract claim. However, without a preliminary notice, you may not be able to take advantage of these other options. In conclusion, failing to pre-lien in a tenant-in-common arrangement can have serious consequences. It is essential to take the necessary steps to protect your payment rights, including serving a preliminary notice and consulting with a construction law attorney. Let's delve more into the practical steps for drafting a preliminary notice of lien. Firstly, accurately identify all parties involved. This includes the property owner or owners, the general contractor if applicable, the lender if any, and yourself as the claimant. Use official names and addresses to avoid any confusion or legal challenges later on. Secondly, provide a clear and concise description of the work, services, equipment, or materials you furnish to the project. Be specific and avoid vague language. Include details such as the type of work performed, the quantity of materials supplied, and the dates of service. Thirdly, state the estimated value of the work, services, equipment, or materials you provided. This should be a reasonable estimate based on your contract or the fair market value of your contribution to the project. Be prepared to justify your valuation if necessary. Fourthly, include a statement of your intent to file a mechanics lien if you are not paid. This is a crucial element of the preliminary notice, as it puts the property owner on notice of your potential claim against the property. Use clear and direct language, such as if payment is not received, the claimant may file a mechanics lien against the property. Fifthly, comply with all statutory requirements for the content and format of the preliminary notice. The specific requirements vary from state to state, so it is essential to consult with a construction law attorney or review the applicable statutes in your jurisdiction. Sixthly, use a standardized form or template for your preliminary notice. This can help to ensure that you include all of the necessary information and comply with all legal requirements. There are many free or low-cost templates available online, or you can create your own custom form. Seventhly, review your preliminary notice carefully before serving it. Check for any errors or omissions, and make sure that all of the information is accurate and complete. It is always a good idea to have a construction law attorney review your preliminary notice before you serve it. Eighthly, keep a copy of your preliminary notice for your records. This will serve as evidence that you served the notice and that you complied with all legal requirements. Also, maintain records of all invoices, contracts, and other documents related to the project. Ninthly, serve the preliminary notice promptly and properly. Timing and method of service are critical to preserving your lien rights. Consult with a construction law attorney or review the applicable statutes in your jurisdiction to determine the proper method of service. Tenthly, track the deadlines for filing a mechanics lien. The deadline for filing a mechanics lien varies from state to state, so it is essential to know the deadline in your jurisdiction. If you are not paid by the deadline, you must file a mechanics lien to protect your payment rights. In summary, drafting a preliminary notice of lien requires careful attention to detail and compliance with all applicable legal requirements. By following these practical steps, you can ensure that your preliminary notice is valid and effective, and that you are protecting your payment rights.